Welcome to DRTSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello and a warm welcome to Ravichandran Swaminathan ji. His often repeated words. If opposition fails, DRTSPR channels through wonderful guests like Ravichandran Swaminathan ji and scores of other guests, they make India stronger being in the opposition. Opposition means for the heck of, no. We go as per rule of law, constitution, invoking evidential act, with no enmity against individuals, nor animosity against any parties or organizations. That is our thumb line, and our wonderful guests are also. Why? Because today again, in continuation with the spirit of yesterday's show, how all the three wings of the constitution, namely the legislature or parliament, the bureaucracy, administration, and the judiciary, how the three combine and a melodrama is created. Supreme Court postpones a crucial hearing on Union plus Election Commission's amendment to 1961 People's Representation Act, wherein they don't want to give any information in regards to the polling footage and the vital information. Such a horrible thing, and Supreme Court postpones the trial for 2 weeks. Don't you think all these three under Constitution, they have come together? Otherwise, how can Supreme Court postpone such an important issue? That beats my intelligence. Supreme Court Chief Justice and all those justices, you can correct me. My number is 9440465339. Is it not by postponing you are harming the basic structure of the Constitution, which clearly defines and states until and unless there is a free and fair election, the spirit of people participatory constitutional democracy cannot survive. And I am the complainant right from 2018. Nothing has been done. In the same pursuit, now, as if that is not enough, the Tamil Nadu governor sitting on the bills passed by the Tamil Nadu Assembly. Is the Tamil Nadu Assembly elected by the people or not? First, the President of India has to clarify. This Supreme Court also. And Dhankarji, the Vice President and the Chairman of Rajya Sabha, has to clarify. He keeps on bulldozing there on the floor of the parliament as opposition vents as and when they come out. Is he not carrying the spirit of one party, Mr. Dhankar? Now you have passed such a serious strictures against a Supreme Court judgment. And Supreme Court, now Ravichandran ji will expose how confused the Supreme Court is these days. I'm very sorry to say, we have shown you how confused the Supreme Court is. You can correct me. You are touting and vouching for 400 acres of Hyderabad Central University land. Then jolly well forgetting 2,900 acres, my dear Supreme Court, forest land, which is the lifeline for Hyderabad. Without 2,900 acres, which you have given away for naval radar, again, you are not qualifying whether it is ELF or VLF, extreme low frequency or very low frequency. How can Supreme Court be so ambiguous? You are not protecting 2,900 acres, and that land belongs to Ramalingeshwara Swami. And Hindu gods, RSS is keeping quiet. Endowment land, you talk about Waqf and all that nonsense. But how is that you are allowing 2,900 acres? Similarly, new High Court in Biodiversity Rich Agriculture University. The same Supreme Court Chief Justice comes and inaugurates. Now see the fate of Supreme Court judgment justices. This is where I say ambiguity. Now, Ravichandran ji will expose. At the same time, even Dhankar ji, you are again exposed being elected by a party. India means we the people. We are supreme. Below us our constitution to see that day-to-day work hold is done, and for which we have elected representatives and selected administrators. But how is that these three, and then to check them, the judiciary. But how is that these three are trying to control we the people? This is nonsense. This is not democracy. Sir, first your forward so that then I'll show all.
Good evening, Dr. Reddy. And thank you for having me on your show. We the people. The preamble to the Constitution starts with, we the people have come together to give ourselves a constitution. So, first the people have come together and they have given themselves a constitution to govern themselves. Or in other words, we people have come together, we have given some of our rights, fundamental rights to defend ourselves, right for sustainable living, right to privacy, right to dignity, right to liberty. All these rights we have given it to the state, and the state is governed by the Constitution. We have enshrined these rights in the Constitution and given powers to the state to govern us according to the Constitution without intruding on our fundamental rights. Now, how should this process work? Now, let us be very clear. The Constitution, the state, both of them are only custodians of power. They do not own it, which means they cannot take powers for which they are not entitled to. That is why the framers of the Constitution introduced lots of checks and balances in the Constitution, so that no single wing, whether it be the legislature, whether it be the judiciary, or whether it be the government, the governing body, bureaucracy, or the state, or even the media, which is considered the fourth pillar, none of these can arrogate to themselves powers to which they are not entitled. So this is our basic structure of the Constitution. This cannot be changed. This cannot be changed by anybody, including the Parliament. If I want to change the basic principle of the Constitution, then the only way that I can change it is bring an amendment to the Constitution or reconstitute the Constituent Assembly, prepare the laws and take it back to the people for them to vote. That is the only way that you can amend the basic principles of the Constitution. There is no other way you can amend it. So everybody in the Constitution has got only limited powers. So this has been very clear. Now, in the Constitution, what happens is the President appoints the Supreme Court judges. The Parliament or the members of the Parliament elect the President and the Vice President. You bureaucrats are appointed by the government. So we have got a clear demarcation on all these things. The role of the president is like the monarch of England, King of England. And according to the Westminster pattern of constitution, which we have adopted, it says very clearly, Rex non potest peccare, which means the king no king can sin. That means you cannot prosecute the king. In all our government tenders, if you see, the president signs at the bottom. Now, this legal dictum says that the president is above all this, you cannot prosecute him. Now, that will give unlimited powers to the president. So, to prevent that, the Constitution said that the president can be impeached by the Parliament. And why they gave the powers to the Parliament was because the president was elected from the Parliament, through the Parliament. So, in a manner the parliament has given appointment to the president, therefore only the parliament has the powers to remove the president. That is why impeachment can be done only by the parliament and only by both the houses, Rajya Sabha as well as Lok Sabha sitting together. The same thing applies to the Chief Justice of the Supreme Court also. They can be impeached only by parliament. The Prime Minister or the governing, the executive portion of the government or the President cannot dismiss the Chief Justice just like that. The Parliament must impeach them, the President must sign that. So it is very clear.
Yep.
It is very clear. What is the role of the Supreme Court? The role of the Supreme Court is to interpret the laws passed by the Parliament. And they have to ensure that no law passed by the Parliament affects the basic structure of the Constitution.
Wonderful.
This is what the Supreme Court said in Keshav Bharati case. That was a landmark case. And in that case, it made clear conditions saying that the basic principles of the Constitution cannot be changed. So, the role of the Supreme Court is limited to interpretation of the law and to ensure that no unconstitutional law is passed by
The Parliament.
the Parliament.
Yeah, wonderful.
Now you see, these portions have been upheld by the Supreme Court itself.
Yeah.
Now, in this present case, Tamil Nadu government assembly has passed certain laws.
Yeah.
Now, the governor has not given assent to it. The governor has also not said why he is not giving assent to it.
Yeah.
He is just keeping quiet. So, under these circumstances, what should the state government do? Now, the state government has got two options. Either it tells the governor to pass the bills, or it takes the case to the Supreme Court and tells the Supreme Court to compel the governor to pass the bill.
Yeah.
So it should go to the Madras High Court, Chennai High Court, and then only it can go to the Supreme Court. It cannot approach the Supreme Court directly. So this is a mistake that the Tamil Nadu government also did. Now, what should the Supreme Court say? The Supreme Court should have told the governor, either pass the bill or reject the bill.
That's it. Simple.
Simple. And you will have to do it within certain period of time. Otherwise, we will be constrained to advise the president to compel you, to dismiss you from the governor's post.
That's it.
This is the only thing that the Supreme Court should have done.
Done. Wonderful. But
now the Supreme Court has gone one step further and said that the governor should pass a bill within 3 months. Now what happens? Now let me ask you another question.
Yeah.
Now the assembly has passed a bill saying that we will teach only Tamil in Tamil Nadu.
yeah.
No other language can be taught.
Yes.
Now that is unconstitutional.
Very unconstitutional. Same Fadnavis
Now,
is doing in Mumbai. Fadnavis is doing
Now
in Mumbai.
should the governor accept it or reject it?
He should reject it outrightly.
He can't. Now, because of the Supreme Court orders, he can't reject it.
No, he can't.
He can't. Now, if suppose somebody takes it to court and tells that the governor and the legislator have passed an unconstitutional bill, because the governor has signed it.
Yes.
So, what happens? An unconstitutional bill has been passed by the legislator and approved by the governor.
Yeah.
Is it acceptable?
Coerced by Supreme Court's order.
Now, what is the Supreme Court going to say? Is it going to say that it is how can you say now it is unconstitutional? Because you yourself have passed a law now saying that the governor is bound by what the legislator says.
Hmm.
This is why I said that Supreme
Yes.
Court should think before giving a judgment.
Very ambiguous.
And Section 142 does not give the Supreme Court the powers to overrule the president.
Yeah.
Or question the president, because there is another principle in law. Judicium parium svorum aut leges terre, which means you can be judged only by your peers.
Okay. This is wonderful.
Now, a reporter just to give you an example, a
Yeah.
reporter of a newspaper cannot correct the editor of the newspaper.
Yeah, he has to just report.
He has to just report. He cannot correct the editor because it is the editor who is appointing the reporter, not the reporter is not appointing the editor.
Yeah.
You got my point.
Yes.
Now, Section 142 of the Constitution gives the Supreme Court to intervene in certain cases, not in all cases. And that section cannot be used to overrule the president and say that the president is also subject to judicial review. The president can never be subject to judicial review. That is the fundamental basic principle of the Constitution. The president's action can be challenged,
Not the
but
president.
the president himself cannot be challenged.
Yeah, that's wonderful. Wonderful.
Now, what the Supreme Court has done is, it has given a timeline for the president to give his assent or dissent, whatever it may be, which is exceeding the powers of the Supreme Court. Now, what happens? The Supreme Court has also said that the Constitution directs the president to act on the advice of the Council of Ministers.
Very ambiguous.
So, the president is bound by the advice of the Council of Ministers. There is no ambiguity in that.
No ambiguity.
The Council of Ministers will give the advice, the president acts.
Next.
Full stop. Now, if the Council of Ministers delays giving advice to the president by, say, 4 months, and according to the new judgment of the Supreme Court, if the president does not give assent within 3 months, it is deemed to have been passed. And after 4 months, if the Council of Ministers comes back and says that don't give assent,
What will they do?
then what will you do? Or in other words, now the Supreme Court has arrogated the power to itself to decide whether to give assent or dissent to a law which is actually the president's prerogative and not the Supreme Court's prerogative. This is where the Supreme Court has made a major blunder by interfering in the work of the legislator. The Supreme Court is, the Supreme Court has got now arrogated itself to powers like an unelected tyrant or a dictator.
Yeah.
Unanswerable to anybody. Is the Supreme Court above the Constitution and therefore above the people? No. It is the people who are above the Supreme Court or even the judges.
Yeah.
That is why we have said we the people who have come together. It is not the Supreme Court has come and given this thing.
Yeah. This is like.
And the entire problem, you know where it has started?
I know.
It has started because of the 52nd Amendment to the Constitution. Our Constitution, our Parliament is composed of individual members. We elect a person, an individual. We don't give our vote to Congress party or to BJP party or to ADMK or to TRS or to BRS or to XYZ party. We are giving our vote to a person who is representing the party. That's all.
Wonderful.
So the 52nd amendment says that Ayaram, Gayaram, when in those days politicians were jumping from one party to another, the anti-defection law came into effect, and which said that if a person votes against the party ideology, he can be thrown out from parliament. So the party started issuing a whip. Or in other words, the fundamental principle of the constitution was changed in the 52nd amendment when parties started issuing whips. It is now no longer that I give my vote to an individual. I give my vote to the ideology of the party, which is wrong, which is against the constitution, which has to be challenged.
Supreme Court was sleeping. It
Yes.
doesn't interfere in such matters. This is what you brought out. Supreme Court, where were you on the 52nd?
Where were you then?
Why Supreme Court kept quiet? All
Why
those
Supreme Court kept
wonderful justices. Why did you keep quiet? Is this not a conspiracy against the Constitution of India? And we, the people of India, we have.
And we are, Dr. Reddy, we are facing the problem now because of that. Because I'll tell you why. Today, any party in power, BJP or Congress, they can put their candidate and ask everybody to vote for them on the pain of being disqualified under the anti-defection law.
Yeah.
Or in other words, now the president or the vice president or the speaker of the house, or even for that matter, any election commission constitutional post, all of them are being appointed by the party, not by individual members. The individual MPs do not have the right to express their opinion. Or in other words, the people who have elected the MPs and MLAs, their voice is not being heard.
Wonderful. That's why this we are again projecting.
That is why this issue has come.
This issue.
What you said earlier is correct. Whether it is the BJP or the Congress or this thing, it is the party head who tells, vote for this man, vote for this man. It is not you and I, the people who have the real power, telling them whom to vote for.
Wonderful. So I've just put it across on the screen. Thanks to Partyless India's, their main agenda. So I'm again displaying to remove the confusion from the people, citizens of India. We, the people of India, we are supreme. It is the constitution which is we are framed from the Constituent Assembly's discussions, deliberations, born out of people's wishes. Again, let me make it clear. The Constituent Assembly, for framing the constitution, is solely dependent on the wishes of the people. It is not an ambiguous Constituent Assembly which has framed the constitution. It is based on the wishes of the people. And if there has to be any change in such constitution, again a Constituent Assembly has to go to the people of India. That means we, the people of India, and they have to ask the aspirations or the wishes of the people has to be ascertained, and accordingly they have to be deliberated in a transparent and accountable way in the Constituent Assembly for the changing the Constitution of India. Am I right or wrong, Sarji?
Basic principles, yes. Basic principles of the Constitution can be changed only in that manner. It cannot be changed by a constitutional amendment. It is against the Constitution. The 52nd amendment itself is against the Constitution.
Now, through Ravichandran ji and DRT channels questioning the wonderful justices of Supreme Court, hitherto and the present, why were you silent during the 52nd amendment of the Constitution, which has really created all these ruckus, which has destroyed the spirit of constitutional democracy?
Correct. Exactly. Exact words which are to be used. The spirit of the Constitution was destroyed by the 52nd amendment. Very rightly said, Dr. Reddy.
Why Supreme Court has been keeping quiet all the while? Sirji. Now, why are you creating this mess again? Acting against the president, not the actions. Sirji, please. Now you can, this frame is there, now you can explain to the people so that
See,
they will understand it very clearly.
This is now the president and the vice president are being elected through an indirect election. Actually, it is not an indirect election. They are appointed by the members of the parliament, Rajya Sabha, Lok Sabha, and also the state assemblies. The governor and the president, vice president. It is the elected. See, this is where it comes. Why 52nd amendment is a problem. President, vice president, governor, not the governor, vice president and the vice president are elected by the representatives of the people. They are not elected by representatives of the parties.
Wonderful.
The election, the constitution says that they should be elected by the representatives of the people. 52nd amendment has changed that, and they have said that president and vice president are elected by representative of the parties.
That is
Which means the chairman or the head or the president of the party will decide who your president is going to be or who your vice president is going to be, and the so-called representatives elected to the parliament will have to abide by that and not by the will of the people.
wonderful. Wonderful. So the will of the people has been defeated by this 52nd amendment. Supreme Court
Correct.
kept quiet. Why? Why all this while Supreme Court did not understand, or as I am showing it here, as a melodrama being enacted by the judiciary in support of the parliament or legislature and administration. Sirji, your comments. And when was this amendment brought out? 52nd amendment?
During Rajiv Gandhi's period.
Rajiv Gandhi's period. So that anti-defection law.
Yeah,
In the name of anti-defection law, they have subjugated the powers of the will of the people of India.
Correct. The
What
problem started there.
Problem started there. And these honorable chief justices and justices, how is that you could not understand such core aspect of the constitution being taken away, the will of the people being taken away by a few selected party presidents or chairmen dictating terms to elect a constitutional head of India, where he is not elected by the will of the people of India. Now, in such a scenario, a Supreme Court again trying to dictate terms to the president who has been elected by the party's president, the presidents of the political parties, and the same president has elected you. So that is why my statement was Supreme Court in an ambiguous situation wherein it failed to come to the rescue of the will of the people, that is the constitution.
Correct.
You are supposed to check, comment, or the legislature's passed bills were put to scrutiny as per rule of law. And in a similar way, you were supposed to, Judiciary Supreme Court, to come to the rescue of the will of the people of India vis-a-vis the basic structure of the constitution. To see that no elected representative, either of any parties, they try to overshoot the basic structure, the principle of the Constitution of India. If that has to be, it has to be through the wishes and aspirations of the people by constituting again a constituent assembly, which has to deliberate again, go back to the people, and the people's will has to prevail there. Instead, Supreme Court failed us. Your statement, sir.
See, now in this particular case, see, the problem is the Supreme Court itself is controlled by about 400 families.
Yeah.
The entire Supreme Court Supreme Court judges are all alumni of a single college, single central law college,
Yeah.
alumni of a single CLC, they are the Supreme Court judges, which means no other advocate can become a Supreme Court judge. It is controlled by only 400 families,
Collegium,
which
they
is
call.
a very dangerous
Collegium, they call.
situation.
They call collegium.
Collegium.
So
The
you
collegium,
say
who is the collegium?
these some judges passing such type of judgments, this is preceded by so much of cash caught at a High Court, Delhi High Court judge's house. Are these acts wherein some judges owning their allegiance to a political party now trying to destroy that collegium so that a wider, again, politically parties controlled in the name of independent judicial commission, they are going to appoint their own, again, judges, advocates. So again, the conspiracy, as has been done in 52nd Amendment, now this is also a bigger conspiracy, sir.
Correct. See, actually, the actual situation was a panel of names should have been given, comprising of the Chief Justice, the incumbent Chief Justice, drawing up a panel of judges who can be promoted as Chief Justice, sitting along with the executive, the speaker, and these three people will deliberate and say, okay, this person can be selected as a Chief Justice. See, it is out of a panel of judges, names, a panel of names. And the president will appoint it on the advice of the ministry. This is the actual position. Now, what has happened? The Supreme Court has formed a collegium of judges and they decide who is going to be the next judge. Where in the world has any department got the powers to appoint itself? Appoint its own head.
Yeah. Appoint its own head.
This is a ridiculous situation now.
But at the same time, Ravichandran ji, at the High Court level, it is the political party, the ruling party in power. They are trying to select some names and send it to the panel.
Correct.
And those are the ones, again, Supreme Court will form a collegium in that selected list by the political parties at the Supreme Court level. Now they are forming grouping. They are being regrouped.
So what happens now is one Supreme Court judge nominates or persuades the party in power to nominate his son, and his son becomes a judge, and he is elevated as a Supreme Court judge from the collegium. Or he appoints one person or his son, and that man appoints this judge's son. So it becomes a collusion between these two. That is why the power is concentrated only among the 400 families. It is not coming out at all.
It is not coming out at all. I'm just showing what has happened, our discussion. So Supreme Court, you should not have spoken on such matters. Singhvi criticizes Vice President, all the political parties. The will of the people, where are the people of India?
Who is talking about the people?
Only you and me, and yesterday now only 5 people. The will of the people of India is represented by only 5. Otherwise, it is the political parties. So Supreme Court has done a lot of injustice by not putting 52nd Amendment to a proper legal scrutiny. End of the show. This should be the one which we will be carrying. That is why now we find, now even Sibal, he says he is the president of Supreme Court Bar Association, calling Article 152 nuclear missile extremely problematic. Sibal on Vice President comments against it. But he is not trying to understand and educate us how it has been. I will just play some audio.
I am wondering, the judges will be appointed under Article 124, and a consultation word was used. Consultation is not concurrence. Article 124 was very specific. And with respect to Article 124, we have a very important discourse by Dr. B.R. Ambedkar and the court. I think to allow the Chief Justice practically a veto upon the appointment of a judge is really to transfer the authority to the Chief Justice,
Correct.
which we are not prepared to vest in the president or the government of the day. I therefore think that is also a dangerous proposition. But in the second judge's case, in 1993, the court interpreted consultation will be read as
Yeah, you are reading some part of it, Mr. Vice President, but the basic aspect is how are you elected? Is it not by the same parties? And
Correct.
those judges who have been elevated to the Supreme Court, hitherto were again proposed by the same political parties at the state level. Am I right or wrong, Sarji?
Correct, correct. See, the problem is you scratch my back, I scratch your back. That's all.
Mr.
And
Vice
who is, and now it is called, pot is calling the kettle black. What was the vice president doing? After all, he is the speaker in the Rajya Sabha. He could have introduced a law saying that the checks and balances will have to be followed. And this is not the forum where the vice president can come out and say that the Supreme Court is wrong. If he had wanted to say that the Supreme Court judgment is wrong, he should have talked about it in the Rajya Sabha, of which he is the speaker.
There you should have allowed discussion. Then you would have been
Yes.
he would also been exposed by his own idioms. See, here I'm
Correct.
going to say, why were you calm on this, Mr. Vice President? Supreme Court gives time to Union and ECI for response on challenge to conduct of election rules. Supreme Court denying access to polling footage and records, Mr. Vice President. You are elected by those representatives of the parties again. Why were you keeping quiet? You did not pass any comment here. So this is the ambiguity of Rajya Sabha chairman, and he himself is an advocate, Vice President of India, and the ambiguity of Supreme Court in not coming to the rescue of the will of the people when 52nd Amendment was being passed in the Parliament. Supreme Court was just lying low or else in a sleeping stage. Now, because of that, now this type of federalism wherein the state and the governor, state governor and the union government, state governor, union government, and the president of India now dragged into the Judiciary Supreme Court. Those are supposed to be working under the ambit of Constitution, above the will of the people, me and you and everyone. We are their Maharajas. The Constitution we have submitted to ourselves to govern ourselves in day-to-day activities, whether it is development or otherwise. And they have clearly demarcated boundaries not to exceed or come into each other's, whether it is judiciary, the elected legislature, bureaucracy, or the fourth pillar, as you rightly said, the press. But unfortunately, you are vitiated this atmosphere by coolly understanding in the case of this bill, in this crucial case, wherein you have postponed, and in the other aspect, in Tamil Nadu's case, you are trying to meddle and dictate terms to the president, not to his actions. Last word, sir.
Last word. In the case of the Tamil Nadu government also, when the Tamil Nadu government took the case to the Supreme Court should have said, since the president has appointed the governor, we direct the president to remove the governor because he has not acted as per Constitution. The Supreme Court should have limited its judgment to that purpose only, and they had the powers to do it. By putting a time